whoa, you serious? Wow. So then she further testified that he was aware of the deal.
Listen, y'all. We got Big Meech, Tammy Cowins, all right, and the agent Keith CROMER. Don't forget Keith CROMER. That's the one that was getting from Tammy, okay? And then threw the whole case away. Went crazy. Listen, Dionne CUFFY Gatling's court documents, full reading. We're going to go through a full reading so that we can start to break down some of this, man. I know I've watched it here and I'm watching in piece here, but maybe we could break it down, take our time or something. We'll figure it out. We could play some audio clips, anything we need to do. Listen, this is the Go Network. I'm Uda on Go. Salute to all of y'all. Everybody in the chat is the Go Gang. Be a part of the Go Gang. Subscribe to the channel. Turn the notifications on. And make sure that you're notified when we on Go. Because we always on Go. Trust me.
Special Agent Keith CROMER testified that Flenory was aware of the deal. Flenory just wanted to make sure that his name wasn't in any court documents.
So he that's some typical rat shit. I'm a rat and tell you everything you need to know. Just don't put me on blast.
Yeah, man, listen, man, this shit's simple, man. This shit ain't that complicated, man. This nigga called me in 2013, a nigga called me. Yo, bro, what up? Yo, check this out. I got some good people, man. Yo, I got to get off this joint.
He was looking at the death penalty.
It's crazy. That's crazy. But we are going to go into a little reading and see if we could break down this information, man. See if we could break down all this information, man. Because there's a lot going on in this whole case. We're seeing a lot going on with Tammy, and it just seems like it just seems like the situation is not ending, for real. And we're hearing different little parts about her being in court, her actually wanting to clear the court out. We seen that. We seen that Keith CROMER ended up coming out and speaking, right? And when Keith CROMER came out, Keith CROMER came on court and spoke, all right? And he said that Demetrius, he said that, I'll just say Meech. He said Meech is aware of the plan that they had to set people up. You feel me? So I think this is a technical one right here, y'all. Because everybody's trying to prove that Meech snitched, but Meech didn't snitch per se. You know what I'm saying? It's about some people getting set up. And did Meech know willingly and set them up? This is what this is about. That's why it's more harder for people to prove it, and people have more suspicion about it, even though they hear CUFFY in jail speaking out, saying what he feels happened to him, and he got the court records to prove it, right? So we are going to go into a little read. Let's see what we could do with this, man. A little breakdown, right? A couple people in there don't matter to me, right? So look. We're going to go into this case. All right, now. So we're going to go into the memorandum first, all right? This matter was referred to the undesigned United States Magistrate Judge for all pretrial matters pursuant to 28 U.S.C. 636B, currently pending before the court, is defendant's amended joint motion and memorandum to suppress wiretap evidence following the Franks hearing documents 402, 454, and 459. Defendants contend, it said, defendants contend evidence resulting from court-authorized wire interception should be suppressed first, because under the rationale of Franks v. Delaware 438 U.S. 154, 1978, the affidavit submitted in support of initial application for wiretap authorization contained false information and omitted material information that, once stricken and or considered, deprives the warrant application of probable cause. Defendant's second ground for suppression is the affidavit submitted in support of the wiretap authorization failed to satisfy the necessity requirement set out in 18 U.S.C. 2518 1C and 3C, right? Y'all drop likes, y'all, right? More people join us and we get into the read, right? Salute to y'all on the way and hope you had a happy Sunday. Yeah, you know how we do it. Defendants challenged the validity of the wiretap affidavit under Franks after learning that a DEA Atlanta Group Supervisor Keith CROMER and one more of his direct reports were being investigated by the Officer of Professional Responsibility, or OPR, and the Office of Inspector General, OIG, for, among other things, an allegedly inappropriate relationship between Agent CROMER and a confidential source, which is Tammy Cowins. Improper payments to the confidential source and falsified reports to justify improper payments based on what was known about the investigation at the time. The United States conceded that defendants were entitled to a Franks hearing and agreed to disclose material related to the investigation to defense counsels. The Franks hearing began on October 17, 2016, and continued daily until October 21, 2016. The hearing was recessed from October 21, 2016 until January 9, 2017 to permit time for the parties to obtain cell phone data and telephone records whose relevance became apparent during the course of the hearing. Testimony resumed on January 9th and 10th. And the hearing was recessed again until January 19th due to witness availability. The hearing concluded on February 14, 2017. After all evidences was submitted, the party requested were granted leave to file post-hearing briefs. After several requests for additional time were filed and granted, a motion was fully briefed on September 21st, 2017, and is now ready for a ruling. After carefully considering the parties' written submissions and all of the evidences presented during the evidentiary hearing, I make the following findings of fact of conclusions of the law. Fact 1 in the findings. A, the Title III warrant affidavit and the order. On August 28th, 2012, Assistant United States Attorney Tiffany Becker appeared before United States District Judge Henry E. Autry and made an amended application for interception of wiretap communications over the Sprint brand cellular telephone resold to Total Call Prepaid bearing the telephone number 314-598-2330 with electronic serial number ESN 268-435-460-00333-2743. Referred to in the application's affidavit and orders as target phone number 1. The application was accompanied by and referenced the affidavit of TFO Buds, which was also signed and sworn to by Judge Autry on August 28, 2012. The affidavit was. The facts that formed the basis for the wiretap authorization were set out in the affidavit and can be roughly grouped into 5 categories. First, affidavit asserted facts regarding events of August 5th, 2012, which triggered the investigation. Namely, the affidavit asserted that on August 5th, 2012, a confidential source being utilized by DEA Atlanta CS1, that's Cowin. Y'all drop likes, y'all. More people are doing it. That's Cowin, right? Alerted DEA Atlanta agents to a suspected drug transaction occurring in St. Louis between suspected source of supply, Fidel Suarez, and defendant Dionne Gatling. Specifically, CS1 advised DEA Atlanta agents that she was contacted by Suarez, CS1 is Tammy, who said he had a truck in St. Louis for a suspected narcotics transaction with Gatling. Suarez was having trouble reaching Gatling and asked CS1 for help. In attempting to help Suarez get in contact with Gatling, CS1, Tammy, I'm just calling her Tammy, had a flurry of calls with Gatling and Suarez. Tammy was ultimately successfully in connecting. No, she was ultimately successful in connecting Suarez and Gatling, who was using the telephone that became the target of the wiretap. Second, the affidavit asserted facts relating both to CS1 Tammy reliability as an informant and measures DEA St. Louis investigators took to corroborate information provided by Tammy as CS1's reliability. The affidavit the affidavit attested that CS1 was cooperating with the DEA for monetary gain, had been shown to provide reliable information to DEA regarding a multitude of felonious activities, and had provided information that resulted in the arrest of at least one individual and seizure of drugs and currency. As for corroboration by DEA St. Louis, the affidavit asserted that the DEA St. Louis investigators corroborated information from CS1 by using toll analysis of devices used by CS1, Gatling, and Suarez on August 5th, 2012. Court-authorized precision location information, past criminal investigations, information from DEA Atlanta agents who monitored some, but not all, of the calls between Gatling, Suarez, and CS1 on August 5th, 2012. Third, the affidavit asserted facts related to a suspected drug distribution conspiracy between MEECH, Dionne Gatling, and Fidel Suarez. More specifically, the affidavit asserted that Demetrius Flenory was the purported national leader of the BMF, drug trafficking organization, and had been sentenced to 30 years imprisonment for drug trafficking activities. Okay? The affidavit further asserted, y'all get some likes up for me, y'all. We're going to get some likes up. Some more people want to read this, but they're not getting a notification because I just dropped the stream, you know? It says, the affidavit, right, further asserted that based on information previously known to DEA St. Louis, Dionne Gatling was a member of St. Louis BMF, was an associate of Flenory, had substantial ties to multiple BMF members, had been indicted in the Eastern District of Missouri on drug trafficking charges, and sentenced to 120 months incarceration for drug trafficking. Affidavit asserted that based on information from CS1 and independent investigations by DEA St. Louis agents, Suarez owned and opened and operated a trucking company in California and had been investigated and or arrested without conviction for suspected drug trafficking in 2005 and 2009. But in addition, an independent investigation by DEA St. Louis agents revealed 2 large quantity drug seizures from a truck operated by Suarez's trucking company. Finally, the affidavit attested that, based on information CS1 provided to DEA agents, Atlanta agents at that, Flenory and Suarez became associated while both were incarcerated and for monetary gains. MEECH arranged through Tammy for Suarez to provide in multiple kilos quantities for Gatling, though. Fourth, the affidavit asserted facts related to contacts between CS1, Tammy, Gatling, and Suarez in the year leading up to the events of August 5th, 2012. Specifically, the affidavit asserted that Toll analysis of devices used by Suarez and Gatling indicated that they had been talking regularly since March 2012. Y'all get the likes up for me, y'all. Drop a like. More people going to join us. I love y'all. Happy Sunday. Taking my time reading this thing for y'all. I love you. All right? Cool. March 2012. And that let me come for the last sentence so we know exactly where he's at. It says the phones was used by Suarez and Gatling indicated that they had been talking regularly since March 2012 and that Gatling began using the target telephone in February 2012. The affidavit also asserted CS1 had contact with Suarez and Gatling and was aware that Suarez had been in contact with Gatling and traveled to St. Louis prior to August 2012. But Tammy was not involved in any drug transactions directly with Suarez and or Gatling, and CS1 did not participate in any early conversations between Suarez and Gatling. Thus, Tammy could not relay the content of those earlier discussions. According to the affidavit, CS1 advised investigators of a trip Suarez took to St. Louis in July 2012. Suarez's presence in St. Louis in July 2012 was corroborated by an investigation of Suarez on July 23, 2012. Independent of this case, in which DEA agents in St. Louis surveilled and questioned Suarez for suspicious conduct described in the affidavit. Fifth, the affidavit attested that a wiretap was necessary. Specifically, the affidavit described various investigative tools that have been considered and or used in an investigation to date, including physical surveillance, use of confidential informants, undercover officers, pen registers, telephone toll records analysis, witness interviews, search warrants, and trash pulls, interviews with target witnesses, and use of grand jury proceedings, review of police records, use of electronic surveillance, cellular location data, and tracking devices, and prior Title III intercepts. The affidavit recited in detail investigative tools used in the investigation and why each tool had not been successful and or was unlikely to be successful. On August 28, 2012, Judge Autry signed an amended order authorizing the interception of wire communications of target telephone number 1. The order states that the court found probable cause to believe that the listed individuals were committing violations and that the communications concerning the offenses were likely to be intercepted. The order further found that normal investigative techniques had been tried and had failed, reasonably appeared to be unlikely to succeed if tried, or were too dangerous to be employed. The order authorized the wiretap interception for 30 days. B, the OPR and the OIG investigations, right? Get the likes up, y'all. Get the likes up. Get the likes up. I know how to read, y'all. And the Super Bowl's on. It's coming on. Drop a like, right? So look, right? Documents contained in the court electronic docket in this case reflect that on March 18, 2015, former retained counsel for Gatling advised the government via email that Tammy had contacted one of his associates, claiming, among other things, that the wiretap affidavit was factually inaccurate. Tammy also reportedly told the associate that the DEA agent in Atlanta who was referenced in this affidavit had been suspended or was under investigation. Attorney for government apparently looked into the allegations and advised the court and defense counsel that the DEA office professional responsibility was in fact investigating possible misconduct of one or more DEA agents, providing material information to the investigation in this case, including DEA Atlanta Group Supervisor Keith CROMER, aka Agent CROMER, aka she gave him the pterodactyl neck, Facts. He done threw his career out the window. Fixed. Right? So boom. At a hearing on April 27, 2015, the United States conceded on the record that based on what was known about the internal investigation, all defendants were entitled to a Franks hearing. The United States further acknowledged that defense counsels were entitled to additional disclosures related to the investigations pursuant to the government's obligations under Brady, Bagley, and Giglio. Sounds Italian. Because defendants had already filed pretrial motions at the time of the hearing, defendants were permitted to supplement their previously filed motions and to file any other substantive pretrial motions that are unrelated to electronic surveillance evidence. Now, at a status hearing on November 4th, 2015, the United States disclosed that there was additional information related to internal OPR investigations, as well as a criminal investigation by officer of the Inspector General, the OIG, that had been only recently revealed in St. Louis by prosecutors. Agent CROMER, pterodactyl, Agent CROMER and some of his direct reports were targets of the OPR and the OIG investigations, and documents from the investigations reflect that Agent CROMER contested that the claims of misconduct. He contested them, right? The United States produced OPR and OIG documents on a rolling basis to defense counsels between February 2016 and the early part of May 2016. Now, C, the evidence presented at the Franks hearing, right? At the evidentiary hearing, the United States presented testimonies of 6 witnesses and documentary evidence regarding the veracity of the statements in this affidavit. Specifically, the United States presented the testimonies of Tammy, who testified about the events of August 5th, 2012, and about the relationship between Tammy, Meech, and CUFFY and Suarez. The United States also presented a testimony of a retired DEA Atlanta Special Agent, Jack Harvey. That was the guy that was on MEECH from the beginning, who testified about how Tammy came to be a confidential source for the DEA. Tammy's role while Agent Harvey was controlling agent for Tammy, and events leading up to the OPR and OIG investigations into Agent CROMER and others. The DEA Atlanta Special Agent James Davidson testified about the threats directed to Tammy in the spring of 2015 after electronically filed court documents in this case became publicly available. Finally, the United States presented testimony of DEA St. Louis agents who had responsibility for preparing the affidavit. Task Force Officer Robert Lang, TFO Lang, and the defendants presented testimonies of 7 witnesses and documentary evidence regarding the veracity of the statements in the affidavit. The relationship between Tammy and CROMER, payments made to Tammy by or at the direction of CROMER, and Tammy's contribution or lack of contribution to the investigations for which Tammy received a form of compensation. Specifically, in addition to cross-examine the United States witness regarding the statements in the affidavit, defendants presented testimonies of Agent CROMER. And the following, let me see, that's I skipped now, right? Okay, Agent CROMER, yeah. Agent CROMER and the following former direct reports of Agent CROMER, DEA Atlanta Task Force Officer David Aguilar, TFO Aguilar, DEA Atlanta Task Force Officer Frederick Swoop, and Task Force Officer Anthony Smith, and that's all the officers. Defendant also presented testimony of DEA Atlanta Special Agent Mara Hewitt. Her name is Mara, probably. Mara Hewitt. Special Agent Mara Hewitt. Agent Hewitt who was the case agent on an investigation for which Tammy received compensation, but according to Hewitt, provided no known information of value. And the DEA task force officer, Tyler Hooks, who was also involved in the same investigation with Hewitt. Finally, defendants were presented deposition testimony and testimonies of Agent CROMER's former supervisor, retired Atlanta DEA Special Agent Agent Murphy, who testified about the DEA policies and procedures surrounding the payment of confidential informants and Agent Murphy's involvement in the events leading up to the OPR and OIG investigations of Agent CROMER. Based on my observations of the witnesses during the hearing, I found that all the witnesses presented by the United States to be credible witnesses, with the exception of Tammy, whose testimony was not entirely credible for reasons addressed more fully below. I similarly found the defense witnesses to be credible, although their testimonies was not always direct relevant to the narrow issues before the court. To extent a defense witness's testimony was not fully credible, I have noted that below. 1. CS1, which is Tammy. Tammy first became a confidential informant for the DEA in Atlanta in 2009 when she provided information in a money laundering case which resulted in a successful prosecution and conviction of an individual named Terry White. Although Tammy was not initially a paid DEA informant, CS1's controlling agent, Agent Jack Harvey, put Tammy in for an award that would be a percentage of the value of property forfeited by White because information provided by Tammy was so beneficial to the DEA and how they made the seizures from Terry White. After Agent Harvey retired in 2011, Tammy became a paid DEA informant under the supervision of TFO Swoops. DEA Atlanta Group Supervisor Keith CROMER, although the precise scope of Tammy's duties after Agent Harvey's retirement is not entirely clear, Tammy testified credibly that she was paid on a monthly basis for things like picking up money or drugs, making phone calls and drug investigations. According to the testimony of Agent CROMER, Tammy was paid on a monthly basis for providing actionable information, i.e. information that could lead investigators to a drug source of supply in an ongoing long-term drug investigation. For example, according to Agent CROMER, information Tammy had was that Fidel Suarez, a California-based Mexican national known to law enforcement to be a suspected drug distributor, and Gatling or Cuff were conspiring to engage in drug trafficking activity was the sort of actionable information for which Tammy might receive a payment, right? Sometime after Tammy became a paid informant, in violation of the DEA policy, Tammy and Agent CROMER developed an intimate personal relationship. Specifically, according to Tammy's CS1, Tammy and Agent CROMER developed a relationship that started off as a friendship and evolved into a sexual relationship that lasted through 2012. At 2012, Agent CROMER admitted that his relationship with Tammy became personal in violation of DEA policy, but denied that it was ever sexual in nature. There is no evidence that either the St. Louis agents who prepared the affidavit or the Atlanta agents who worked with Agent CROMER and Tammy were aware of their relationship. Although Agent CROMER testified that all of the payments made to CS1 during her tenure as a paid informant were proper, testimony of Agent Murphy, TFO Smith, as well as Agent Harvey, called into question the propriety under DEA policies of Agent CROMER's authorizations of payment to CS1 on nearly monthly basis. The testimony of Harvey, in addition to testimony of Hewitt and Hook, suggested that Tammy may have inappropriately received an award for an investigation for which Tammy was actually provided no actionable information. However, there was no evidence presented to suggest that Tammy lacked personal knowledge of the information incorporated in the affidavit at issue in this case, and or that in providing information to agent CS1 was somehow taking credit for information known by another informant. 2. CS1's relationship with Meech, Suarez, and Gatling. When Tammy became a DEA informant, Tammy was and had been a longtime friend and associate of Meech. Tammy held Meech's power of attorney and life rights with creative control, the right to tell, and presumably sell Meech's life story for profit. Those rights, by Tammy estimation, could be worth as much as $1 million. Harvey and Agent CROMER were aware of Tammy's relationship with Meech. Tammy You feel me? So they basically, how did she know these two niggas? So this is why Cuffy in there like, yo, bro, y'all got me. Y'all set me up. The hell y'all talking about, right? So in September 2011, Flenory requested CS1's help coordinating delivery of a load of cocaine to be controlled by Suarez, who at that point was already in contact with Tammy. Tammy credibly testified that she first met Suarez by telephone when Suarez contacted Tammy to ask how Meech was doing. Meech confirmed that he and Suarez were friends and that they had met in the county jail in Michigan. Although Tammy did not meet Suarez in person, she spoke with Suarez on the phone and text. Additionally, Suarez sent Tammy a picture of himself. Suarez asked Tammy if she knew someone who might want to buy some pills. According to Tammy, she was in the car with Agent CROMER during the first narcotic-related conversation with Suarez. Agent CROMER overheard the call and signaled for Tammy to say yes. Tammy was later contacted by the agent in California regarding Suarez. As with Suarez, defendant Gatling first contacted Tammy to see how Flenory was doing in jail at 60. No, ID at 60. That's the numbers. To see how Flenory was doing in jail. Based on discussions with both Gatling and Flenory, Tammy understood that Gatling and Flenory were friends. Initially, Tammy's relationship with Gatling was more of a business relationship and communication centered more around Meech's life rights. However, at some point, Meech asked Tammy to connect with Gatling and Suarez, and the relationship between Tammy, Gatling, and Suarez turned to narcotics. Telephone toll records reflect that Suarez and Gatling were in contact with each other on various devices from as early as March 2012 through August 2012. Although telephone toll records show that during the same time period, Suarez and with less frequency, Gatling were in contact with Tammy, there is no evidence to suggest that Tammy participated in any of the early telephone calls between Suarez and Gatling. Suarez invited Tammy to join him on a trip to St. Louis without stating why he was going to St. Louis. Tammy declined. Telephone toll records reflect that Suarez contacted Tammy while Suarez, was in St. Louis. At the evidentiary hearing, Tammy denied that Meech had any involvement in any drug trafficking activities between Suarez and Gatling and denied that Tammy ever informed DEA agents that Meech was ever involved. Tammy also denied that she ever informed DEA agents that Meech directed Tammy to connect with Gatling and Suarez. So now her story is changing because before she said Meech is the one who initially connected her with both Suarez and Gatling. She's from Atlanta, Suarez from Cali, Cuffy's from St. Louis. How the hell she know these people? Feel me? However, this aspect of Tammy's testimony is not credible for at least 3 reasons. First, Tammy's testimony conflicts with the testimony of TFO Lang and the DEA St. Louis agent who interviewed Tammy about the events of August 5th. TFO Lang credibly testified that during his debrief of Tammy on August 6, 2012, Tammy told him that Tammy had facilitated the introduction of Gatling and Suarez at Meech's request. Second, Tammy's testimony also conflicts with the contemporaneous interview notes of DEA Atlanta investigator TFO Smith, which were introduced into evidence. Those notes are consistent with assertions in affidavits regarding Meech's involvement in the suspected drug conspiracy. Finally, evidence presented at the hearing demonstrated that CS1 faced actual and perceived threats when court filings in this case revealed her identity. Specifically, on February 6, 2015, all defendants in this case filed pretrial motions, including separate motions to suppress wiretap evidence in March 2015. Tammy reviewed the electronic docket in this case and saw information contained in defendant Gatling's suppression motion and responsive submissions by the United States that Tammy believed would potentially allow people familiar with the circumstances to determine Tammy's identity. Upon reviewing the court filings in this case, Tammy contacted her controlling DEA agent at the time, James Davidson. Agent Davidson testified at the evidentiary hearing that Tammy expressed concern that motions filed in this case and the government's response to those motions contained specific details, informations that Tammy feared would reveal her identity or make it much easier for someone to figure out who Tammy was and figure out her identity. Tammy was panicked and took several measures to try to protect herself. Those measures included contacting the underdesigned magistrate judge whose chambers referred to Tammy to the United States Attorney's Office and driving several hours to Louisiana soon after learning about the court filing to attempt to see Meech to try to explain her position and try to deflect any accusations coming Tammy's way. Although it appears that Tammy did not speak with Meech in Louisiana on March 6, Tammy's hearing testimony suggests that when Tammy did finally speak with Meech, he advised Tammy he didn't want his name caught up in the mess. In addition to Tammy's perception that she was in danger because of revelations, Agent Davidson credibly testified that Tammy faced actual threats in the weeks and months following the court filings and in March 2015 through the time of the Franks hearing. In a further attempt to protect himself, in the spring of 2015, Tammy stated in a draft affidavit that a wiretap affidavit contained false information and outlined different versions of events from what is set out in the affidavit. Tammy never signed the affidavit or swore to it, but Tammy relayed some of the information in the unsworn affidavit to the documents though the documents were not filed under seal and have since been ordered sealed. So she had those documents actually sealed as well. Okay, y'all make sure y'all all subscribe to the channel. Y'all drop likes, right? Gatling's former counsel, DEA agents, and prosecutors from the U.S. Attorney's Office in St. Louis. Tammy also threatened to circulate the unsworn affidavit to all parties involved, included the underdesigned. Tammy's unsworn affidavit specifically takes issue with the statements in the wiretap affidavit suggesting that Meech hooked up the deal between Gatling and Suarez. The unsworn affidavit suggests instead that Agent CROMER implicated Meech because he was jealous of Meech's relationship with Tammy. This backdrop of actual and perceived threats to Tammy diminishes the credibility of Tammy's testimony and instead very strongly suggests that perhaps due to Tammy's personal and business relationship as well as out of concern for her own safety and the safety of Meech, Tammy had an incentive to attempt to distance Flenory from Suarez and Gatling. On August 5th, 2012, on Sunday, August 5th, 2012, at approximately 11 a.m. Eastern Time, Suarez began contacting Tammy using two different telephone numbers. He sent Tammy text messages from telephone number, whatever, and placed voice calls to Tammy from a cell phone from another number. Specifically around 11 a.m., Suarez sent Tammy a text message asking Tammy to call Cuff, aka Gatling, and tell him to give Suarez a number so that Suarez could talk to him. Testimony of Agent Johnson, Tammy responded shortly thereafter, indicated she would do so when she got home. A little more than an hour later, at approximately 12:18 p.m., Suarez placed a voice call to Tammy, and when he did not reach Tammy, he sent a text message indicating that he was trying to call and asking Tammy to pick up. In apparent response to Suarez's request, Tammy placed a call to Dion Gatling at approximately 12:43 p.m., but did not reach him. Suarez's desire to connect with Gatling and Tammy on August 5th appears to have been a matter of some urgency. Between 12:18 and 1:05 p.m., Suarez placed 14 calls to Tammy and sent a text asking if Tammy was still busy. It appears from toll and telephone records that at approximately 1:05 p.m., Suarez finally connected with Tammy by telephone and spoke with Tammy for approximately 1 minute and 35 seconds. Although it does not appear that Suarez actually spoke with Tammy prior to the call at 1:05 p.m., it appears from the evidence of records that Suarez left one more voicemail on Tammy's phone, and that Tammy accessed those voicemails during the relevant time frame on August 5th. After speaking with Suarez at 1:05 p.m., Tammy sent Agent CROMER a text message around 1:09 p.m. asking him to call back and indicating it was just business. At the time, Agent CROMER was returning by car from an out-of-town trip with his family and did not immediately respond. At 1:11 p.m., Suarez sent Tammy a text with a phone number. 15 minutes later, at 1:26, Suarez texted again, just in case he didn't know it was 314, apparently referencing the area code to the 4269 number he had just texted. At 1:34 p.m., Gatling returns Tammy's earlier call and left a voicemail. At 2:06 p.m., Tammy returned Gatling's call and spoke with Gatling for approximately 4 minutes and 30 seconds. After the call with Gatling, Tammy once again called Agent CROMER, who finally called Tammy back around 2:17. Once Tammy made contact with CROMER, Tammy spoke with Agent CROMER for over 7 minutes, presumably bringing him up to speed. Toll and telephone records established that Tammy attempted to reach Gatling around 2:24 p.m. Around the same time, Gatling called Tammy using the telephone number that became the target of the wiretap. Gatling's call from the target telephone was routed to Tammy's voicemail. At approximately 2:24 p.m., Gatling called CS1 Tammy using the target telephone, and unbeknownst to Gatling, Tammy added Agent CROMER to the call via three-way calling. Around the time of the three-way call between Tammy, Gatling, and CROMER, Suarez sent Tammy a text asking if Gatling had answered Tammy. Responding by text, Tammy stated, yes, he's trying to call you now, and you are not picking up, to which Suarez responded, give him that number I gave you, the 314 number, the new number. I lost the other one. Tammy contacted Agent CROMER immediately after receiving this information from Suarez, and then, based on toll records, received a call from Gatling around 2:29 p.m., during which Tammy provided Gatling with the new number from Suarez. Toll records reflecting at a 10-minute call between Gatling and Suarez shortly after Tammy spoke with Gatling. Although the telephone and toll records do not reflect the content of the discussions between Tammy, Gatling, and Suarez, Tammy credibly testifies that when she spoke with Suarez on August 5th, Suarez was upset and frustrated because he had been trying to reach Gatling without success. Suarez indicated in words or substance that he was trying to deliver a shipment of narcotics to Gatling. He expressed a sense of urgency in connecting and contacting Gatling, indicating he had an effing truck up there, and suggested Gatling was playing games. To contact Gatling, Tammy had an alternate number for Gatling, and as the toll phone and as the toll and telephone records discussed above clearly demonstrate, Tammy reached out to Gatling and as Suarez requested. At the evidentiary hearing, Tammy testified that contrary to the statements in the affidavit, Agent CROMER was physically present with Tammy in Tammy's home during Tammy's calls with Suarez and Gatling. Tammy's further testified that because he was physically present, Agent CROMER overheard the content of the calls with Suarez and Gatling. Denied that Agent CROMER overheard any of the calls via three-way call. This aspect of Tammy's testimony is entirely not credible in light of the other evidence of record. Specifically, Agent CROMER credibly testified that over the weekend of August 5th, he was in South Carolina on a family trip. Agent CROMER credit cards records which were retrieved during the hearing corroborated his testimony, as did aforementioned tolled records. The toll records reflect that Tammy sent text messages and placed telephone calls to Agent CROMER after first receiving the calls from Suarez on August 5th, and reflect that Agent CROMER participated in at least one three-way call with CS1 and Gatling. Agent CROMER testified that the statements in the affidavit recounting the events of August 5th were true, including statements that he overheard the conversations between Tammy and Suarez about the truck. However, it was clear from observation, his testimony, that Agent CROMER was unable to independently recall with any specificity, fuck man, hi man, it's late, right? And the content of the discussions between CS1, Suarez, and Gatling on August 5th, 2012. That's docket numbers. Nor could he recall whether he overheard live discussions between Tammy and Suarez and or Gatling, or if he overheard records, voicemails, or recorded messages played back by Tammy. As set out above, telephone records demonstrate that Tammy CROMER overheard one back. Let me hold on. I'm going fast. Telephone records demonstrate that Agent CROMER overheard one conversation between Tammy and Gatling via the three-way call, but there is no evidence of a similar three-way call between Agent CROMER, Tammy, and Suarez, although it is not entirely clear how Agent CROMER learned that Suarez told Tammy he had a effing truck up there in St. Louis and was trying to reach Gatling. The credible evidence of record suggests that Agent CROMER either overheard Suarez make the statements when Tammy played back the recorded voicemail from Suarez, or he overheard Suarez's statements because Tammy repeated it to Gatling while Agent CROMER was listening on the three-way call between Gatling, Tammy, and CROMER. Regardless of how he learned of the content of Tammy's discussion with Suarez, Agent CROMER relayed the content of that discussion to DEA and St. Louis agents at or near the time these events were unfolding. Telephone toll records reflect that beginning around 3:48 p.m. on August 5th, Agent CROMER made multiple calls to DEA St. Louis desk agents and to DEA St. Louis group supervisor Kevin Merkel. Testimony by Agent CROMER, in addition, testimony by Agent Johnson, TFO Lang, established that on Sunday, August 5th, 2012, the DEA St. Louis office received notice from DEA Atlanta that an individual named Fidel Suarez had a truck believed to contain shipments of narcotics in St. Louis destined for an individual known only to the DEA Atlanta offices as Cuff. Because DEA St. Louis was already very unfamiliar with the name Cuff as an alias or nickname of defendant Dionne Gatling, DEA St. Louis Group Supervisor Kevin Merkel assembled a team of investigators which included Agent Johnson and TFO Langs and Buds to follow up on the information received from DEA Atlanta. On August 6, 2012, the St. Louis Investigative team, which included Agent Johnson, TFO Lang, and TFO Bud, spoke with Agent CROMER and perhaps other agents in Atlanta on a conference call. Agent CROMER advised the St. Louis team of investigators that on August 5th, a DEA confidential source, Tammy, had been contacted by Fidel Suarez, a suspected drug transporter or source of supply. Agent CROMER advised the St. Louis investigators that in attempting to put Gatling and Suarez in contact with each other, there had been a flurry of phone calls between Tammy, Suarez, and Gatling. The DEA St. Louis agents obtained Agent CROMER's permission to contact Tammy directly. Finally, this initial call with Agent CROMER the St. Louis investigative team decided to pursue investigations as such as TFO Lang continued the background investigation by conducting interviews of Tammy later on August 6, 2012. TFO Buds also pursued additional background information on August 6 by contacting physical surveillance of Gatling and conducting a trash pull, right? Which yielded nothing of evidentiary value. In debriefing Tammy on the evening of August 6, TFO Lang confirmed what had been reported by Agent CROMER and incorporated the affidavit recorded the evidence and the events of August 5th. TFO Lang, with 3 different telephone numbers for each individual used during on August 5th, 2012, including target telephone number 1, the subject of wiretap authorization. Tammy also elaborated on a flurry of telephone calls with Suarez and Gatling. When TFO Lang asked Tammy about the relationships between Suarez and Gatling, Tammy told Lang that Tammy had facilitated an introduction of Suarez and Gatling at MEECH's request for the purpose of connecting Suarez so that he could be supplying Gatling with multi-kilos quantities of yay. TFO Lang and Suarez and Flenory had met while this is what she told TFO Lang, that Suarez and Flenory, they both had met while they are incarcerated in the county in Detroit, Michigan in 2005, and that Flenory was going to receive some sort of financial benefits based on the drug trafficking relationship between Suarez and Gatling. Tammy told Lang Tammy had never met either Suarez or Gatling, but advised of a telephone or text contact with both. Informed Lang of at least one instance where Tammy was aware of when Suarez visited St. Louis, which would have been in July 2012. Tammy was aware of the visit because Suarez called Tammy and invited Tammy to meet him in St. Louis, but Tammy declined the invitation. Due to the St. Louis investigative team's knowledge and experience with Gatling as a sophisticated large quantity drug distributor, and due to the team's knowledge of Suarez as a California-based large-scale drug distributor or source of supply, the team decided to pursue a Title III investigation. Agent Johnson, at that time, different people within the group were tasked with different responsibilities, but the team worked collaboratively in conducting the investigation and incorporating their findings into the affidavit. As the most experienced member of the team, Agent Johnson was asked with drafting the affidavit and analyzing telephone toll records of telephones used by Gatling and Suarez. Lang was tasked with investigating the individuals involved to learn more information about them, including researching DEA and for criminal records and other criminal investigations. Buds, TFO Buds, was tasked with surveillance and locating historical information on the subjects of investigation. Agent Johnson's analysis of the telephone records and telephone toll analysis corroborated information provided by Tammy. For instance, telephone toll records demonstrated that consistent with Tammy's information, Tammy had extensive contact with Suarez in the year leading up to August 5th, 2012, and that Tammy had also been in contact with Gatling prior to August 5th, 2012. Although to a lesser extent with Suarez, toll and telephone records analysis together with other historical information regarding Suarez's travel and his trip to St. Louis also confirmed that consistent with Tammy's information, Suarez was in contact with Tammy in July 2012 when he traveled to St. Louis. Telephone toll analysis further corroborated Tammy's information regarding the sequence of calls between Tammy, Suarez, and Gatling on August 5th, 2012. In addition to the above-mentioned telephone toll analysis, St. Louis agents were also able to corroborate information provided by Tammy through PLI data. Historical information obtained by the DEA by the DEA and the St. Louis police databases about Suarez, physical surveillance, and the team's own collective historical knowledge of Gatling, MEECH, and the Black Mafia family's drug trafficking activities. The PLI data and physical surveillance of Gatling's residence in assessing the reliability of information provided by Tammy and St. Louis agents also relied on representations by Agent CROMER that he had overheard the calls between Tammy, Gatling, and Suarez on August 5th, and that Tammy had a history as a reliable DEA informant. Based on their investigation and the collective experience of the St. Louis investigative team, Agent Johnson and his team concluded that The conventional investigative tools such as physical surveillance, confidential informants, search warrants, trash seizures, electronic toll records, witness and or target interviews, grand jury investigations, police reports, and other electronic surveillance such as trap and trace devices and tracking devices and other methods would be of limited and used in advancing the it would be limited of use in advancing the investigation. As such, the St. Louis investigative team applied for and on to August 28, 2012, obtained judicial authorization for a wiretap of Gatling's phone target telephone number 1 used on August 5, 2012. Conclusions of the law. A motion suppress electronic surveillance evidence based on Franks v. Delaware. In Franks v. Delaware 438 U.S. 154164, 1978, the Supreme Court held that under limited circumstances, a defendant may attack the veracity of an affidavit after the warrant has been issued and executed. In so holding, the court recognized that notwithstanding the presumption of validity that attaches to an affidavit supporting a warrant when the Fourth Amendment demands a factual showing sufficient to comprise probable cause, the obvious assumption is that there will be a truthful showing. As such, under the rationale of Franks v. Delaware, a search warrant may be invalid if the ensuing judge's probable cause determination was based upon the affidavit containing false or omitted statements made knowingly or intentionally with reckless disregard for the truth. United States, that's just the penal codes. To prevail on Frank's claim, defendants must establish by a preponderance of the evidence, one, that a false statement knowingly and intentionally or with reckless disregard for the truth was included in the affidavit, and 2, that the affidavit's remaining content is insufficient to establish probable cause. The same analysis applies to omissions of fact. The defendants must show, 1, the facts were omitted with the intent to make or in reckless disregard of whether they make the affidavit misleading, and 2, that the affidavit is supplemented by the omitted information could not support a finding of probable cause. For an affidavit to be truthful does not mean truth. For an affidavit to be truthful does not mean truthful in the sense that every fact recited in the affidavit is correct. This is so because probable cause may be founded upon hearsay and upon information received from informants, as well as upon information within the defiant's own knowledge that sometimes must be garnered hastily. In determining if the statements were made with reckless disregard for the truth, the test is whether, after viewing all evidences, if the affidavit and have entertained serious doubts as to the truth of their statements, or obvious reasons to doubt the accuracy of the information he reported. Recklessness, however, may be inferred from the fact of omissions of information from an affidavit when the material omitted would have been clearly critical to finding of probable cause. As the Supreme Court explained in the Franks, the focus of the inquiry is whether the affiant, and not any non-governmental informant, deliberately or recklessly made a false statement. The deliberate or reckless disregard whose impeachment is permitted is only that of the affiant, not of any non-governmental informant. Thus, courts have generally held the fact that non-governmental third party lied to affiant, who in turn included the lies in the affidavit, does not constitute a Franks violation. A Franks violation occurs only if the affiant knew the third party was lying, or if the affiant proceeded in reckless disregard of the truth. Frank's violation may still exist if a government agent or an informant acting as a government agent deliberately or recklessly misinterprets information to a second agent, who then innocently includes the misrepresented who then includes the misrepresentations in an affidavit, or deliberately or recklessly omits information that is clearly critical to finding of probable cause. Omissions of the fact that drug sniffing dogs failed to alert on a package was both reckless and clearly critical to the finding of probable cause. This is another number one. The defendants have failed to prove by the preponderance of the evidence that the government agents deliberately or recklessly included false statements in affidavits which are material to finding probable cause. Defendants appear to contend that virtually all of the information in the affidavit that was central to a probable cause determination was false, and suggest that all statements attributed to Agent CROMER and Tammy should be stricken from the affidavit. However, based on the foregoing factual findings, with one exception discussed below, none of the statements in the affidavit that were material to the findings of probable cause were false or misleading. It is significant that the only two witnesses at the evidentiary hearing with firsthand knowledge of the events of August 5th is Agent CROMER and Tammy, who testified consistently about the facts that are foundational to any probable cause determination in this case. Indeed, although the testimony of Tammy and the testimony of Agent CROMER were discordant on a number of points, Tammy and Agent CROMER were simpatico about the following. Fidel Suarez, a suspected source of supply to defendant Gatling, contacted Tammy on August 5th, 2012. Suarez told Tammy he had a truck in St. Louis for a narcotics transaction with Gatling. Suarez was having trouble reaching Gatling and asked Tammy for help. In attempting to help Suarez get in contact with CUFFY, Tammy had a flurry of calls with CUFFY and Suarez. Tammy ultimately successfully contacted Suarez with CUFFY, who also using the telephone that became the target of the wiretap. These facts, which were incorporated into the affidavit and are at the heart of any finding of probable cause to authorize a wiretap of CUFFY's phone, were proven to be true based on the testimony of Tammy and Agent CROMER and other evidence presented at the Franks hearing. As the underdesigned factual findings demonstrate, all the other facts in the affidavit, save that the reference to overhears by DEA Atlanta agents via three-way calls, are true. The affidavit attests to, although the affidavit repeatedly referenced DEA Atlanta agents, evidence presented at the hearings established at those references were almost exclusively a reference to Agent CROMER. A few more pages. DEA Atlanta agents had two overhears on conversations on that date, which were established by telephone by Tammy during three-way calls. The affidavit further attests that DEA Atlanta, Georgia monitored three-way calls connections established by Tammy and were able to hear the conversation live, which included hearing Tammy and the other party of the call, either Suarez or Cuffy, depending on the call. Although affidavit states that not all calls were monitored by DEA Atlanta agents, it attests that DEA Atlanta agents confirmed that their overhear with Suarez was during the call between Suarez and Tammy, during which the time Suarez advised, "I got these effing guys up here with this truck. I need to get in touch with Cuffy." As the factual findings demonstrate, while the affidavit accurately states that DEA Atlanta agents overheard a live conversation between Tammy and Cuffy via three-way call, the affidavit is misleading to the extent it suggests that the DEA Atlanta agents also had a three-way call in which they overheard live a call in which Suarez told Tammy about the effing truck in St. Louis, although Tammy's telephone records clearly show a three-way call between Tammy, Cuffy, and CROMER. No similar entry exists for a call between Tammy, Suarez, and CROMER. The presence of these misleading and perhaps even false statements in the affidavit is not a Franks violation, given the facts of the evidence clearly established that agents CROMER overheard at least one call between Tammy and Cuffy via three-way call, and in light of evidence, Agent CROMER overheard and was clearly aware of content of the call between Tammy and Suarez about the truck. It is entirely possible and plausible that in relaying the nature of the overhears to St. Louis agents, Agent CROMER mistakenly or inadvertently gave the impression to St. Louis agents that he overheard both calls by three-way call. Given the evidence in this case, it is so plausible that St. Louis agents mistakenly assumed that Agent CROMER overheard both conversations via three-way call or failed to realize that with what Agent CROMER actually overheard live was Tammy's recap of Suarez's statement during the three-way call between Tammy and Cuffy. In any event, when all of the credible evidence of record is considered, defendants have failed to establish by the preponderance of the evidence that statements about the three-way call overhears were made with reckless disregard for the truth, or that the affiant had obvious reasons to doubt the accuracy of the information that he reported. In sum, for the foregoing reason, defendant motions to suppress should be denied because defendants fail to prove by the preponderance of any evidence that any government agent or any information acting as a government, as a government agent or any informant acting as a government agent deliberately or recklessly included a false statement in which the affidavit that was material to finding of probable cause. Defendants have failed to prove by the preponderance of the law and the evidence that facts material to a finding of probable cause were deliberately or recklessly omitted from the affidavit. Although defendants' positions regarding omitted information is less than clear, defendants appear to suggest that suppression is warranted because the affidavit failed to disclose Agent CROMER's inappropriate relationship with Tammy and failed to disclose the inappropriate payments he may have authorized for Tammy, information that defendants appear to tactically acknowledge would go to Tammy's reliability as an informant. Defendants can prevail on their Franks omissions challenge only if they prove by the preponderance of evidence that the affidavit deliberately or recklessly omits information that is clearly or critical to the finding of probable cause. First, as the factual findings demonstrate, there is no evidence that any agent involved in preparing the affidavit knew and or had any reason to know that Agent CROMER was having an inappropriate relationship with Tammy, nor is there evidence that agents preparing the affidavit knew or had any reason to know of any inappropriate payments to Tammy, even if, as defendants have suggested, Agent CROMER's knowledge of the relationship and allegedly improper payments can be imputed to the St. Louis agents. Defendants have failed to demonstrate that the omitted information was clearly critical to the findings of probable cause. An omission is in a violation of the Franks only if the defendants make a showing that the agents omitted the information with the intent to make or in reckless disregard of whether they made the affidavit misleading. The failure to include information and reckless disregard for its consequences may be inferred from the fact that the information was omitted only if defendant shows that the omitted material would be clearly critical to the finding of probable cause. For example, in Jacobs, the Eighth Circuit held that information that a drug dog showed interest but did not alert on a package. It did not alert on a package that was subject to search to a package that was subject of a search warrant application was such highly relevant information that any reasonable persons would have known that this was the kind of thing the judge would wish to know. The court concluded that given the highly relevant nature of the omitted information to the finding of probable cause, it was appropriate to infer from its omission that police omitted the information with a reckless disregard of its effect upon the affidavit. The Jacobs court went on to hold that suppression as warranted, applying the second prong of the Franks analysis. The court held that once the omitted information was included in the warrant's affidavit. A couple more pages. As the factual findings in this case demonstrate, the circumstances presented here are easily distinguishable from the circumstances in Jacobs. The omitted information in Jacobs, i.e. negative results of a drug sniff dog, was information that was clearly central to the finding of probable cause. Here, given the significant amount of corroborative information, St. Louis agents obtained the information provided by Tammy and Agent CROMER. It is not at all apparent that the omitted information, which goes to Tammy's reliability as an informant, was clearly critical to the finding of probable cause. To be sure, it is well established that the statements of a reliable informant can by themselves be sufficient be a sufficient basis for insurance of a warrant, and that the informant's reliability, veracity, and basis of knowledge are relevant to finding probable cause when an affidavit is based in substantial part on information from an informant. However, it is equally well settled that an informant who is correct about some things more likely will be correct about critical, unverified facts. Thus, where the informant information is at least partially corroborated, attacks upon credibility and reliability are the crucial to the findings of the probable cause. Because it's undisputed in this case that DEA St. Louis agents were able to corroborate most of the information provided by Tammy and Agent CROMER, attacks upon Tammy's credibility and reliability are simply not crucial to the findings of probable cause. In sum, for the foregoing reasons, defendant motions to suppress should be denied because defendants failed to prove by the preponderance of evidence that the facts of the materials to the finding of a probable cause were deliberately or recklessly omitted from this specific affidavit. Motions to suppress electronic surveillance evidence based on failure to satisfy the necessity requirement. Under 25181C, each application for a wiretap authorization must include a full and complete statement as to whether or not other investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if tried or to be too dangerous. Similarly, fucking hell, requires that in an ensuing wiretap authorization order, the district court must determine whether normal investigative procedures have been tried and have failed or reasonably appeared unlikely to be successful if tried or to be too dangerous. Together, these sections make up the necessity requirement for granting an order to receive wire intercepts from a phone. It is well established that although wiretap should not be routinely used as an initial step in an investigation, the necessity requirement does not require that the law enforcement exhaust all possible techniques before applying for a wiretap. If law enforcement officers are able to establish a conventional investigatory technique, have not been successful in exposing the full extent of the conspiracy and identity of each conspirator, the necessity requirement is satisfied. Indeed, the Eighth Circuit has interpreted the necessity requirement to restrict wiretaps to situations in which they are necessary as well as reasonable, but not to require the government to show the exhaustion of specific or all possible investigative techniques before wiretap orders could be issued. Moreover, whether the statutory requirement is met is a question of fact to be determined by an ensuing judge. In a common sense matter, here, the foregoing factual findings demonstrate that although St. Louis investigators decided early on to pursue the Title III wiretap investigation, the wiretap was not used as the initial step in the investigation. And given the sophistication of the parties and complex logistical challenges, the agents had ample justification for pursuing a wiretap. The affidavit and factual findings described in the various techniques used by law enforcement officials to gather evidence in the case. The affidavit and the factual findings described in detail why some investigative techniques had failed or why they would be of no or limited value. The affidavit explained that the use of various techniques had failed or, based on the agent's experience, would fail to fully reveal the full scope of the conspiracy, its complete membership, and methods of operations. Testimony by Agent Johnson and, to a lesser extent, TFO Lang at the suppression hearing confirmed the facts contained in the affidavit and further elaborated on those facts. In sum, because the facts contained in the affidavit was sufficient to meet the necessity requirement, defendant's motion to suppress electronic surveillance evidence should be denied. In conclusion, for all foregoing reasons, defendant's joint motions to suppress electronic surveillance evidence should be denied. Signed, Shirley Padmore Mensah, United States Magistrate Judge, and dated this on the 12th day of January 2018. Shit, we got through that, bro. Yo, and you know I never slept all day, right? I don't know how I just read that shit. I can't even see. Word, nigga, I can't. That thing was blurry. Word, I haven't slept all night since early when I was streaming, yo. You heard me? I love y'all all. Make sure y'all all subscribe though. Tap in. Make sure y'all all subscribe to the channel. I got some dope stuff. I got some people that's also around the case and stuff that's gonna be coming on the channel and speaking with me too. And I've got some other little stuff. I will be following the case in detail. But I want to bring in some people that actually know some things to come and join us. So make sure you're notified. So subscribe and hit the notification bells. You heard? I've been fiending to take 2 pulls of some 420 that whole time. I ain't drink no water. Did I stop it? Look, I didn't even drink water. People can't tell me I can't read. Okay? And I dropped out of school at a very young age. So imagine that. So when I tell people I taught myself some shit, I'm proud. I don't care what nobody said. I don't got no degree to prove it, but fuck it. I'm proud. Yeah, man. Salute to y'all, though, man. Salute to y'all. I was thirsty as hell, y'all. I was damn near dying. I almost croaked. Y'all don't even know. Y'all would have called cops to help me. Y'all don't even know where to send them. I'd have been in here dead. Salute to all of y'all. What's up? Flora, what's up? Where y'all from? All the people that's in the chat, where y'all from if y'all still here? Salute to y'all. P's and Q's is in the building. Sexy Nate pulled up. What's up, Nate? You know what I mean? June 5th, Newark. A couple of people. Okay, Trail pulled up. Okay, Key popped out. Okay, the atypical developer. That's cool, man. Yeah, man. I hope y'all all subscribe, man. I hope y'all all subscribe. You know, because we've been watching people break stuff down in piece by piece by piece. You know what I mean? Let's get to it, man. Fuck it, man. I just read it, man. Oh, you from London? I was in London. I was living in London, Flora. Don't you forget me, Flora. Stay close. Stay close, Flora. Facts, Flora. Yep, I was living out there, Flora. I was living in England for over a year. I was out there doing film and all of that. Facts. Yeah. Yeah, add my channels, though. I got 2 channels linked here. You hear me, Flora? Add my Comedy on Go and add my News on Go. And add me on Instagram if y'all want to add me on Instagram. And y'all can leave me messages on Instagram if y'all want to tell me something. Add me. Add me too, Flora. Add me on Instagram. Send me a message. Y'all send me a message. What part of London you from, though? You from England or you from London? Because, you know what I'm saying, people from England, we want to come squeeze up in London. Nah, man, you from the Midlands, get up out of here, man. You know you from Leicestershire. Don't do that. You from Aylesbury or something. Don't do that. What part, Flora? Oh, what's that? Instagram? What's that, Instagram? My channel is this. Add me right now. My channel is Udo and Go on Instagram. Same thing. Same channels. Same channel name. Just add me and send me a message, then I'll know it's you. Because I be having so many people in my messages. It's crazy. But what part of London you from? Oh, Islington. Oh, I think I heard. Yeah, okay, cool. You from Islington? That's cool. That's cool. I never got a chance to go there. I think I told you that, right? I never got a chance to go. You told me that already, right? The other day, right? I remember you told me that. That's fact. England is dope, man. England is dope. England is dope. England is real. Yep. England is dope, bro. Trust me. Shit's lit. I ain't going back, though. Like that. I'm going somewhere else. Yeah, I gotta come to the States. Because when I was out there, them niggas was like, yo, the hell you doing here, son? This place is shite. It's shite here. What you doing here? Get out, you old geezer. Word. It was like, what are you doing here, bro? Facts of life, son. Facts of life. Oh, shit, I'm smoking up, motherfucker. My bad. Shit. Facts of life. How long this shit is? This shit was long as shit, yo. Can't even hold you. Pause no Diddy with that one. Diddy's in the prison. Pause. No Diddy. Yeah, yo. Salute to y'all. Make sure y'all all tapped into these channels, all right? I'm going to be back with another stream. You know I do my late night streams, too, as well. Hit me on the gram, son. Udo and Go, bro. That's it. Simple. Hit me on the gram. Especially if you think you think. Hit me on the gram. Make sense? So, yeah, man. I love y'all, man. I love y'all all. Y'all stay tuned in. Stay tapped in. Don't get your shit tapped in. You know the bop. Facts of life. Yeah, I don't believe me. I'm crazy. I don't think I do, but hopefully some people that think they know me's in here. They probably think they know. So listen, y'all. I love y'all all. I love you all. I need y'all all to subscribe to both of the channels linked to my channel. Okay, that's first things first. Subscribe to both of the channels. All right. Comedy on Go, News on Go. I need y'all to subscribe to both of them. Get them to 50, and I'm gonna start going live. And I'm gonna start dropping links so that y'all could come up and talk and stop writing to me and talk to me. Y'all wanna talk, right? The fuck? I wanna talk. Like I like people to talk to me. I don't like reading too much. Fuck. Broke up many of my relationships. You want texting Tammy? Not Tammy Cowins, not throat goat Cowins Tammy. I'm just talking about a texting Tammy. That's it. Just a texting Tammy, y'all. I'm not talking about the throat goat Tammy Cowins that sucked the life rights out of Meech, dragging the shit out of Meech, and caught Keith CROMER, had the nigga locking up bums on the street, and he a fed. Yeah, I got you. Yeah, and he a fed. You heard? Got the nigga locking up bums on the street. So all the fellas out there, y'all watch out for that goat throat shit. Y'all think y'all want the throat goat shit? Go ahead, bro. Go ahead with that throat goat shit, bro. You gonna be caught up like Bo Keeb and you gonna be caught up, bro. Get caught up with that throat goat shit, bro. You gonna be caught up like Beach. You gonna be caught up like Agent Krober. You gonna be caught up like motherfucking Andre 3000 with Erica Badu. Yeah. Why you think that nigga ain't singing years? That nigga playing flutes. She took that nigga voice, nigga. Come here, nigga. Took the nigga voice like Ariel, nigga, like the Little Mermaid. Nigga can't even speak. Nigga like the nigga playing flutes, nigga. The fuck? Telling you, nigga, she got that same power that Tammy got. Erica Badu. They got the same power going on, bro. Some real shit. Look at Common. He ain't been the same shit. He ain't been the same since. Look at Common. Telling you. He got a song. The last song he did. There are times. The light, nigga. Why he talking about the light? Telling you, bro. Erica got him. Erica got him. Erica got him. Trust me. Trust me, I'm telling you, I ain't gonna lie to y'all. Yo, salute to y'all, Cleveland, Ohio, the building. Salute to all my people. Remember, all of y'all get the likes up. I'll be back with another one. You know, I go live all the time. You know what I mean? You know, I go live all the time. So, yeah, bro. Y'all just make sure y'all tapped in, man. All right? Salute to all of y'all. I hope y'all blessed. I'm gonna find another topic though. I'll be back with another one. I'm just gonna cap this as a read instead of jog and do something else with it. I love y'all all though. I'll be back with another one in a minute. P's and Q's, salute. Drop your link, P's. Yeah, listen. You know how to drop a link, P's? Did you figure it out? You gotta figure it out. You gotta go to Google, on YouTube on Google, and then the YouTube is the Google. And then you just copy the YouTube. Like when you write in the Google search, it says YouTube. You just copy the link. You go to your channel wall. YouTube, go to your channel. Boop. As soon as it go right there, you don't press nothing. Your channel's there, and then you just click on the search bar. When you hold the search bar, you copy and paste that, and then you place it in here, and then it's gonna pop up blue. Try it and do it before I leave. Salute, James. Salute, bro. Where you from? You from Ohio? Salute to Cleveland, bro. Who y'all got in the Super Bowl? You see, I ain't even give a fuck to watch it, bro, because you know who's gonna win. I'm tired of them. I hope the Eagles win though. But I always root for the underdogs, bro. That's how I do, bro. Who in there? Homeless man? Go homeless nigga. No, you can't win, but fuck it. Somebody gotta have some hope. Fuck it. You know what I mean? Word, I want the Eagles to do it. Straight. But boy is good though, so it's gonna be a bad one. I want it too, man. Hopefully we won, bro. I don't know how it's looking. Yeah, you gotta learn how to drop that link though, peace. I'm gonna be back in a minute with another one. Uda. You know we always on go. This is the Go Network. I am Uda on Go. That chat is the Go Gang. Be a part of the Go Gang. Subscribe to the channel. Hit the notification bells so you're notified when we peppering. You heard? Uda.